Greetings everybody. My name is Nikki Whittier-Nell and I hail from the University of KwaZulu-Natal Law in Pietermaritzburg. There are three aspects that I'm focusing on in relation to the COVID-19 pandemic. The first relates to interprovincial travel, that being banned in terms of the regulations, but nevertheless, obviously, exceptional circumstances have arisen and there are a number of court cases dealing with that. Secondly, I'll be talking about our courts and how they are functioning and whether they can and are ready to function on a remote level. That will be my second topic. And thirdly, we'll be looking at healthcare workers at the front line. What are their rights and what happens if they become infected by a patient at, say, the hospital? And further, what happens if they in themselves then end up infecting another patient at the hospital? So first of all, interprovincial travel. The regulations, the initial regulations that were drafted were very clear and prohibited interprovincial travel absolutely. There were no exceptions and there was no catch-all to the effect that in exceptional circumstances the regulations might be deviated from. So what happened in this case arose in Mpumalanga was that there was a gentleman, Karl van Heerden, who received tragic news from his mother that his grandfather had passed away in a home fire. She was very distraught and Karl van Heerden wanted to assist his mother as well as attend his grandfather's funeral, which was in a different province. He applied to the High Court in terms of an urgent application to grant him permission to travel interprovincially for those purposes. And the High Court said that they were unable to grant his application because they would be authorizing him to break the law by way of a judicial decree, and they indicated that no court was competent to do that. It's important to remember that in the Van Heerden case, there was never any constitutional challenge to the regulations. So there was the regulations weren't being sought to be put aside. Van Heerden was simply applying for an exemption from them. Following on from Van Heerden's case, but unfortunately not timeously enough to allow Van Heerden to attend the funeral, the regulations were amended and the amendments provided that interprovincial travel to attend funerals would be permitted for certain categories of family members. Following Van Heerden's case, there have been three other cases involving people seeking urgent permission to travel interprovincially. One of the cases was in the Pietermaritzburg High Court, where an elderly father, a 76-year-old father, was being forced to care for his son without assistance, his adult son, who was severely disabled. The adult son had autism, epilepsy, brain damage, and various other ailments. Both his legs were broken, smashed in a car accident. And Van Heerden, I beg your pardon, not Van Heerden, the father of this adult disabled child was himself ill and suffering from a terminal illness, and he was terribly concerned that his son would not have any assistance should anything happen to him. The son was also prone to violent, dangerous outbursts, which were not within the son's control, but which were a danger to both the son and the father. The father eventually found a place for the child in Cape Town. The father and the son were situated in Howick, KZN, and they approached the High Court for an urgent application allowing them to travel to deliver the adult son to the facility. This time there was a constitutional challenge to the regulations, and Judge Piet Bezuidenhout in the Pietermaritzburg High Court delivered judgment, unfortunately without giving reasons, but he granted the order allowing travel on strict conditions to the Cape Town facility in order to drop the son off there. The other cases were in Pretoria, the North Gauteng High Court, and the Western Cape High Court. One of the cases involved parents seeking to travel to the residence of their adult child who was suffering from autoimmune disease and was severely ill and unable to care for herself under lockdown conditions. That application was granted. And then there was another case where the children of a couple had been left with their grandparents for a short holiday, and then lockdown intervened, and the grandparents were finding it very difficult to cope, and the children were also very distressed at being separated from their parents for such a long time. In all of these cases, there was nothing in the regulations allowing interprovincial travel. But in these two cases, just like in the Pietermaritzburg High Court, the Judges Mia and Sodwalla, both granted the applications and granted the orders. Subsequent to those cases, there were further amendments to the regulations, excuse me, now allowing interprovincial travel for parents collecting children in circumstances of urgency. And what my research involves is comparing the reasoning of the various courts, as well as reflecting on the dangers of drafting law without going through the processes, because we end up with injustice, such as Van Heerden's case, when laws are drafted hastily without considering every possible scenario. Obviously, this is a time of emergency, so we can't critique it, but it does give us an opportunity to reflect on how valuable the process is leading up to the adoption of new law. The second topic that I'm going to be briefly talking about today is courts and remote hearings. And what I mean by remote hearings is hearings that are conducted by video conferencing technology. That could be on the platform of Zoom, Skype, or in any other way. But it involves a situation where the parties are not physically together in the same geographic location, but they're linked to each other through audio-visual technology, which enables them to see and hear each other in very near to real time, almost exactly real time. I've written previously on this topic, and it is my PhD topic. I've been working on it for some time and have been urging South Africa to move along on this aspect and to develop some kind of legislative framework to enable remote hearings to proceed. The pandemic has now overtaken us, and there is no time to follow the proper legislative channels to draft the necessary legislative framework. But my research has also taken me to countries where principles governing remote court hearings have been developed on a case-by-case basis. India is the country that I focused on in particular in this regard. And the Chief Justice, Mogoeng, has said that the various high courts may use remote technology to conduct hearings at their discretion. Initially, the high courts did not take him up on this. They weren't keen to adopt remote technology, and instead what they did is simply remove the cases from the rolls or postponed the cases. But then with the extension of the lockdown, it became apparent that the courts were not going to be able to be functioning in their usual way anytime soon. So the courts are starting to reconsider their stance. The Supreme Court of Appeal has said that they will conduct their business by way of online technology. And so far there's been an amended directive from the Judge President of the Gauteng Division saying that all appeals and application procedures will be dealt with electronically, remotely, and that hearings may either be postponed to a future date or they may be dealt with remotely in terms of directives which will be developed by the judge hearing the matter on a case-by-case basis. It's not ideal. Ideally, the legislative process that I was talking about earlier should have been followed so that we could have a coherent set of guidelines, but we're in an emergency situation. The courts need to continue functioning, and I'm going to be doing research surveys of the judges, analyzing the cases, and trying to develop a set of rules and guidelines out of this experience through this crisis period. The third area of research is an area which I worked on together with my colleague, Dr. Sheetal Soni, and we considered health workers working on the front line and who are identified by the World Health Organization of workers at a very high risk of contracting the disease by virtue of the nature of their work. Obviously, they will be coming into contact with sick people. We looked at what would happen if a healthcare worker became infected with COVID through interaction with a patient. And we also looked at whether a healthcare worker would be entitled to refuse to work after having come in contact with a COVID positive patient. And here we come across a difficult conundrum, because if all healthcare workers who had had contact with a patient who subsequently tested positive for COVID, if all of those healthcare workers went on leave for a period of isolation, there would be a catastrophic shortage of staff in our hospitals at the time when we need them both. On the other hand, having those healthcare workers still working means that they may be asymptomatic and yet still infectious. So there's a danger of those healthcare workers then passing the virus on to patients. If the healthcare worker themselves contracts the virus while they're at work, in other words, from a patient, we looked at their remedies in terms of the Compensation for Occupational Injuries and Diseases Act, which provides for temporary compensation for temporary disablement as well as permanent disablement, and if they were to die as a result of the COVID infection, their dependents would also have a claim against the fund. COIDAT wouldn't apply in respect of patients who became infected through contact with a COVID positive nurse or doctor, because they would not obviously be employees of the healthcare facility. Their remedy would lie in delict, and they would have to prove negligence on the part of the hospital. So that's an indication and a summary of the 3 areas in which I'm currently working. They're all moving targets. The law and the directives and the guidelines are changing all the time on these topics, and we are hoping to keep up with them and to keep on track and keep informing people of what their rights are and what the possibilities are, as well as, of course, the challenges. Thank you for listening.